The latest court filing by Wendi Adelson could change everything that we were expecting to see in Donna Adelson's trial, and we're going to go through that motion in today's video.
Hey, 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 welcome to the Sofa Squad, sipping from the cup at hey, hey.
Now hold on everybody, let's do a quick sofa sidebar now. Keep in mind, ain't no cop, ain't no doctor, ain't no lawyer, ain't no therapist, ain't none of that fancy credentialed stuff, okay? Only credentials we got up in here is my sass, and this sofa. Now keep in mind also, I'm just giving my opinions on very public information, so do your own research, come to your own opinions, and drop them off in the comment section. And while you're down there, if you do like what you see here at the Sofa Squad, drop a little like, drop a little comment, drop a little share. It helps the channel out immensely. Now let's get to edition. Hello Sofa Squad and welcome back to the sofa. This is the sofa. This is Paul. My name's Paul if you're new to the channel. If you're not new to the channel, well, my name is still Paul. Okay. Now what we're doing today is we're going to be doing a motion read through, and this is in relation to a motion that was filed by Wendi Adelson. Wendi Adelson is Donna Adelson's daughter. Donna Adelson is, depending on when you're watching this, getting ready to be in trial or is currently in trial, just depends on what's going on. So, but regardless, she's getting ready to start trial. This is a few days before jury selection. Donna Adelson is facing several charges in relation to the murder of Dan Markel. This was Wendi's husband. This took place years ago. Okay, many people have been convicted. Many people are in prison, including Donna's son Charlie, Wendi's brother. Okay, so Wendi's the only one that has walked away unscathed from this so far, right? We're kind of crossing our fingers that justice will be served after this trial, but we will see. So she filed this, and we're just going to read through it. The little bit that I know of it so far, I'm just like, oh yeah, girl is definitely trying to protect herself. So what I'm going to do is I'll put it on the screen, we'll read through it, and let's dig in. You see at the top here, State of Florida versus Donna Adelson, the defendant. And then down below it says non-party Wendi Adelson's motion for permission to place a statement on the record and to quash defense subpoena. Next is introduction. So non-party Wendi Adelson is the daughter of defendant Donna Adelson and is expected to be one of the first witnesses called by the state in Donna Adelson's trial. Both the state and the defendant issued trial subpoenas to Wendi Adelson. By law, the state subpoena confers immunity on Wendi Adelson, but the defendant's subpoena does not. Accordingly, Wendi Adelson respectfully moves for permission to place a statement on the record regarding the state of Florida's trial subpoena, the state subpoena, Exhibit 1, and to quash the trial subpoena issued by defendant Donna S. Adelson, the defendant subpoena, Exhibit 2. In support of this motion, Wendi Adelson states as follows. Oh, this is gonna be good, y'all. Let me scroll down. Donna Adelson is charged by indictment with first-degree murder, alleging she participated in a conspiracy to murder Dan Markel, Wendi Adelson's ex-husband, on July 18, 2014. Other alleged members of the conspiracy were charged and convicted, including Catherine Magbana, Second Circuit case number, and it listed the case number. In Catherine's trial, both the state and the defendant subpoenaed Wendi Adelson to testify. In response, Wendi Adelson filed a motion like the instant motion to place a statement on the record and to quash the defense subpoena on May 13, 2022, and it lists the case numbers. Thus, the two trial subpoenas by each party in this case present the same issue the court dealt with in a previous trial. The state subpoena affords Wendi Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights, while the defense subpoena provides no such protections. In the Magbana trial, the court quashed the defense subpoena and granted Wendi Adelson's attorney an opportunity to place a statement on the record. And then it says see exhibit or example, and it lists the thing right here. We'll get to that in a minute. We request the court grant the same relief in this case. Now we're just going to go down here to these little numbers that it has underneath the thing where they were citing the exhibits and examples. So number 2, in the related hearing before the court in the Magbana trial, Magbana's counsel argued that it would be reversible error for Magbana's cross-examination to be limited because the state can tailor their direct examination to prohibit Magbana from going into areas that could potentially be relevant. Based on dicta by the First District Court of Appeal, Magbana's appeal of the prior protective order prohibiting the deposition of Wendi Adelson. In that the opinion, the first DCA did acknowledge that Magbana would be given little latitude in her cross-examination of Adelson because her questions would be limited to the narrow category categories of information the state elicits at trial. It lists the case numbers. However, the first DCA did not grant Magbuana's requested relief in that appeal and recognized that when the Fifth Amendment guarantee collides with the Sixth Amendment in circumstances as these, the Sixth Amendment right must yield, because to require one to incriminate oneself in order to afford help and another would be unwise and unrealistic. And then we'll just skip down. And just this past month, the first DCA again addressed these same arguments by Magbuana. The first DCA found no error in the court's handling of Wendi Adelson's trial testimony, favorably cited Wendi Adelson's counsel's statement on the record, and concluded the trial court properly ruled that she could not be called as a defense witness. Therefore, there's no reason to depart from the procedure employed by the court in the Magbuana trial. In the Magbuana trial, the court scheduled a hearing relating to this requested relief just prior to Wendi Adelson's testimony. Wendi Adelson respectfully requests the court set a similar hearing on this motion outside the presence of the jury prior to her testimony or at such a time determined appropriate by the court. Okay, very interesting. Right now, I get that she's already had this done and whatnot, but regardless, again, remember she's the lawyer, right? So she knows how to dot her I's and cross her T's to stay out of trouble. That's exactly what she's trying to do. Okay, so skipping down to number 2, memorandum of law, and then it says A, the court should allow Wendi Adelson's attorney to place a statement on the record regarding the state subpoena. Wendi will testify pursuant to the state subpoena, but without such a subpoena, she would invoke her rights under the Fifth Amendment to the United States Constitution and Article 1, Section 9 of the Florida Constitution. As a result, Wendi requests that once the state calls her as a witness, her counsel should be allowed to place on the record a statement outside the presence of the jury that number 1, Wendi intends to invoke her Fifth Amendment and Section 9 rights. Number 2, Wendi's testimony is entitled to use and derivative use immunity pursuant to Florida statute, and it lists more of these here. Number 3, use and derivative use immunity extends to any testimony given during Donna Adelson's cross-examination of Wendi Adelson, and it just lists case law and etc. Given the state's theory of the case, there's no question that Wendi Adelson has a real and substantial interest in asserting her rights against compelled testimony. Now let's just go down to B, the court should quash the defense subpoena. Although Donna will have a full and fair opportunity to cross-examine Wendi Adelson at trial, and despite knowing that she would otherwise assert her Fifth Amendment rights, Donna's counsel issued the defense subpoena. Unlike the state subpoena, the defense subpoena confers no such immunity. Now jumping down to the next paragraph, it says the law is well stated that the purpose of, and it lists the number, is to aid the state. A defendant cannot immunize a witness in order to secure the witness's compulsory testimony. It lists some case law. Simply put, the defense has no ability to confer immunity upon a witness under Florida statute, even where the witness is likely to provide an exculpatory and reliable evidence. If called as a defense witness, Wendi would invoke her Fifth Amendment rights to every relevant defense question. Therefore, any testimony Wendi provides beyond the matters covered under the state subpoena would result in a potential waiver of her Fifth Amendment rights, which she does not intend to do. Florida law is equally clear that it would be improper for a party to call a witness for that witness to invoke her rights before the jury. Calling a witness to invoke Fifth Amendment protections in front of a jury creates a dramatic moment, causing irreparable damage and injury to the eyes of the jury. Thus, there is no proper purpose for the defense subpoena, and it should therefore be quashed to ensure the integrity of the trial process and to protect Wendi Adelson from unnecessary harassment and abuse. Under these circumstances, the defense subpoena should therefore be quashed. For the court's convenience, we attach relevant pages from the Magbuana trial transcripts related to this matter. Conclusion: wherefore, Wendi Adelson respectfully requests that the court grant her motion, allow her to place a statement on the record as set forth herein, and quash the defense subpoena. Okay, now before we get into the other stuff, let's just talk for a second. So like I said, clearly Wendi has a vested interest in doing this, right? Number 1, she's trying to stay out of prison. Number 2, she knows how to play the game. She's a lawyer. She does this stuff, right? So she knows what to do. This family is very conniving and very manipulative, so they all know how to work together on these things, okay? So while yes, it's very obvious, if a defense witness gets up there and it's like, I plead the fifth, I plead the fifth, I plead the fifth, even though like from SOFA speculation, SOFA viewpoint, we know that most likely, allegedly, she is, probably had some knowledge of something, but that's just my opinion. And same with Donna, right? We'll see what the court finds out, what the jury decides. But regardless, it would look bad, right? So I can understand that part, but it's also just like, you know, a kick in the stomach because we know why they're doing it. This is not like somebody who, it'd be one thing if you were innocent, right? Or if you're really fighting like some messed up, trumped up charges, you know what I'm saying? But like, come on. Okay, it just feels like we're watching somebody navigate the legal system to get away with something, okay? Now, take all that aside, this just to me is like, would an innocent person be concerned about this? Or would you just get up there and answer the questions, right? Okay. I mean, this is the obvious Captain Obvious 101, right? But that being said, let's get into some of their, you know, exhibits and examples and all that stuff. Okay, now on the screen, we're just gonna go down to these things they have listed. So here we can see Wendy's witness subpoena, okay? Now, also of note, it says dates and time you shall appear, August 21st, 8:15 a.m. through September 5th. Now remember, this is gonna be right in the middle of CrimeCon, okay? I mean, come on now, right? But, so just keep that in mind, right? So there's that. Now scrolling down to the next page, you'll just see here's the subpoena for trial. It's obviously addressed, you know, to Wendi here. And then it says, you're commanded to appear before the Honorable Stephen Everett at the Leon County Courthouse, gives a location, from August 19th, 2025 through September 5th in courtroom 3G for the taking of your testimony in this action. If you fail to appear, you may be in contempt of court. Okay, that's gonna be the least of your worries there, Miss Wendi. Now what we're gonna get into next is some, basically some court transcripts and whatnot from Magbuana's trial. So I'm gonna put them up on the screen, we'll just go through them. So you see it says jury trial, Robert Wheeler's the judge, May 19th, 2022, the court reporter, all that jazz, right? Okay, let's go down here. So the court. Okay, Ms. Kawas, I'm handling Mr. Lacasse, and I did not bring my documents, so I would need to return to the hotel to pick up my documents in order to properly cross-examine him. This is one of the issues we had, Judge, with them not telling us fully who is going to be called. The court, all right, you either are going to need to send somebody or you're going to have to, Ms. Kawas. I might have to, Judge. The court, do it during a break or whatever you need to do. Ms. Kawas, on a break, if I could probably send someone. I just have to be able to have her locate all of them, all the documents. The court, well, it's the fourth witness. Do what you've got to do. I mean, Ms. Kawas, all right, thank you, Judge. You know the state's not required to provide you with every bit of information. We knew that there were 2 other witnesses testifying today. So just make sure that you get your documents however you need to do it. And I'll depend on you, okay? All right, thank you, Judge. All right, thank you. I like to pretend that they're all mad at each other. I don't know why. It just makes it more interesting to read for me. Let's keep going. All right, now the first thing that I want to address is in regards to this Miss Wendi Adelson and a non-party motion that I received. And so is Mr. Loro present? Yes, Your Honor. Good morning. The court. Okay, Mr. Loro, good morning. Let's see. We don't have the podium in a good place at this point, but if you could just go ahead, step right up to the podium. Good morning. Yes, Your Honor, John Loro, and with me is Miss Adelson here. Your Honor, as you know, Miss Adelson has been subpoenaed by the state as well as the defense. She, without a state subpoena, would unequivocally invoke her Fifth Amendment rights. We want to make that clear for the record. In light of Your Honor's prior rulings and direction, we wanted to put that on record. However, with respect to the state subpoena, it automatically confers use and derivative use immunity on her pursuant to Florida Statute 914.04. That use and derivative use immunity would only apply to a state subpoena and not to the defense subpoena. So in light of that, we would ask respectfully that the court quash the defendant's subpoena, since there's no purpose and no appropriate purpose in calling a witness simply to invoke in front of the jury. The court. Let me ask you this, Mr. Loro. Any questions that are given to Miss Adelson during, if she was called with a defense case, is she going to assert her Fifth Amendment rights to any question that's asked at that time? Yes, Your Honor. I'm assuming any question question would have to be relevant and germane to the matters in this case, and as a result, she would invoke as to those questions. The court, all right. And so I'm just going to assert my previous ruling that I've made, and I did restate it on the record yesterday, is that she'll be required to testify under the state subpoena. The cross-examination will be limited to whatever the state brings forth on direct. So that's what the cross-examination scope will be limited to. There's no piggybacking or bringing in any other information just because she's under the state subpoena. That's not going to be permissible. And then she's not going to be permitted to be called as a witness. Now that we know that she's just going to assert her little Fifth Amendment rights, she won't be called as a witness in the defense case at this time. Mr. Loro, yes, Your Honor, that's exactly our understanding of the law. The court, all right. Anything else for the court? No, sir. Okay, well, I'm going to ask that Miss Adelson then please remain outside the courtroom because she's subject to the rule. Yes. All right, thank you. Miss Quashed. And Your Honor, did you want, or are you going to allow defense any argument in addition to what we put in our motions in Lamine? Because our position is right now that what is happening is our cross-examination ability, which was precisely in this case of Catherine Magbuana versus the state of Florida that was issued by the first DCA on this direct issue, warned about this exact thing happening, which is that. And the court even stated that it would be reversible error for our cross-examination to be limited because the state can tailor their direct examination to prohibit us from going into areas that could potentially be relevant. The court, all right, now thank you, Ms. Quashed. We've gone through these arguments before. I think you'd made a record prior, and so, I do appreciate that. You further made your record, so my ruling stands. Ms. Quashed, I appreciate it. Thank you, Judge. The court, all right, thank you. All right, and the first witnesses will be Marcia Rodriguez. Okay, all right. So anything else from the state before we bring the jury in? Ms. Kappelman, Ms. Dugman, is this your witness? Ms. Dugman, no, sir, this is Ms. Kableman. But I did want to follow up with the court with an issue that came up yesterday regarding whether portions of the defendant's testimony might be brought to the court. I did some research myself on that. Ms. Dugman, yes, sir, and I brought some case law for the court. I provided it to the defense, and I can give the court a 2-minute summary of this in an argument, or we can do that at a later time. We don't expect to try to elicit anything or play anything right now. The court, okay, well, if it becomes an issue again that's objected to, then I'll hear the argument at that time. I did do some research of my own in regards to the old admissibility of her trial testimony from the earlier trial. And so based on how it's presented, or if there are any other issues connected with that, then when it's presented as a particular issue, I'll make my ruling at that time. Ms. Duggan, yes, sir. Okay, so let's jump down in the motion, and we're going to go down to another bit of transcript and whatnot. Okay, so it says State of Florida versus Sigfrido Garcia and Catherine Magbuana. And it just, introduces the stuff. Again, this is the Honorable James Hankinson. This is September 27th, 2019. So remember the two different trials, okay? So the court, no, Adelson's. Ms. Kapelman, oh, I'm sorry, yes. So we need to have some discussion about immunity. Is she here? Let's have the witness take the stand. Mr. DeCoste. Your Honor, should I call off my reporter? I'd like to mitigate cost, and I don't think that we'll be at the court. Wait a little while, good Lord. Mr. DeCoste, I don't think we'll be able to complete the deposition today then because we're going to lose the reporter at about 6. Come on up, ma'am. Come on up. Good Lord almighty now. Place her under oath. Good Lord, we ain't got all day. Wendi Adelson. Wendi Adelson was called as a witness, having been the first duly sworn, was examined and testified as follows. The court. And can I get your name for the record, please? Miss Lauro. Yes, Your Honor, it's go to the podium. Good Lord, what are you, just new around here? Miss Lauro. Good afternoon, Your Honor. It's John Lauro. That's Lauro. O as in ostrich. O. And I'm counsel for Miss Adelson. The court. Well, good Lord, all right. Now, it's my understanding that the state is requesting the court to compel Miss Adelson's testimony. Is that correct, Miss Kapelman? Miss Kapelman, yes, Your Honor, that's correct. The court, well now, okay now, based upon that, Miss Adelson, the testimony you provide and anything derived from this testimony cannot be used against you, okay? But you will be required to answer all relevant questions, okay? Now you got that, you understand? Yes, Your Honor. The court. All right, now anything else you want to make record of? Okay, Mr. Laura. No, Your Honor, thank you. The court. All right, now anything else? Anybody? Miss Capleman. No, sir. The court. All right, now go on. Get the jury on in here now. Good Lord, ain't got all day up in here now. Mr. DeCosta. Your Honor, can we get an estimate on so I can tell the reporter? The court. I think she said about 45 minutes. Calm your britches down now. Calm your britches. Mr. DeCosta. Would we then break after the airs and reserve cross for Tuesday? The court. No, good Lord. Now we're going to finish today with this witness. Mr. DeCosta. I understand. I don't believe that we're going to be able to do the deposition today. Okay, and that's it. So I have to go into my different voices just to make it interesting or whatever. So that's all the things there. So let's just talk about it or whatever. Now again, remember, I ain't no lawyer, ain't none of that fancy credential stuff. So this is sofa speculation. Like, we're on the jury. Obviously the jury wouldn't hear this part of it. So like I said, to try and like be non-biased or whatever, yes, I totally get that you would not want a witness to get up there and just invoke the fifth, because it would look super shady, especially since there is a family dynamic going on here, right? Now, in layman's terms, if imagine seeing a trial like this and the woman whose husband was killed that is being alleged that her mom and family had something to do with it, and she gets up and invokes the fifth on everything. Right? I mean, come on. And it's literally what's happening. So it would look super bad. Personally, I would like that. I'm like this. I'm like, no, make her get on the stand and do that. What do we got to hide up in here? If it looks bad, it looks bad because it looks bad. Okay. So clearly, Wendi has many motivating factors for not wanting to answer questions, right? Now, at this point in the game, you know, from what the little bit that I've understood is that Wendi, per her lawyer, was like, you know, and would be obvious in anything. Lawyers like, don't talk to your family about the cases. Remember, most of her family's in jail now over this. So Wendi, in my opinion, kind of got what she wanted. Now, she's not saying that she wanted Dan dead or anything like that, right? But the custody thing's over. She has her kids and she's living where she wants to live. Okay, so who knows what the relationship is like? Now, from what we've understood from other testimony, other evidence, you know, the family very much put Wendi up on this pedestal, like, you know, she's just the end all be all in this family, okay? Can do no wrong. And so I just feel like they're kind of willing to sacrifice themselves for the sake of Wendi. Now, also as far as it goes, just, you know, when you talk about just specifically the parents, right? Donna, Harvey, Charlie, and then Wendi, we're not talking about the estranged sibling who's probably like, get me away from this craziness, right? We're just talking about that. Okay, so Wendi has kids. You know, not that Charlie doesn't or whatever. I mean, I get that, right? But there just seems to be like this, the perfect daughter kind of a thing. She has the kids. That's going to be more important. Like, Charlie's going to sacrifice himself. Blah, 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 blah. Now, of course, none of them were thinking they were going to be called for this. They all very much, in my opinion, consider themselves above the law. Okay. So how will this pan out? I think that most likely it will go the same way that it did in the other things, where she's just going to do a statement and whatever that is, and then the state's going to question her, and I cannot wait to see her on the stand. We've been following, doing some live chats on the live chat channel, the podcast channel, links down below, rewatching her testimony and whatnot, and then some with Donna, just to kind of see what we can expect. And I think Wendi's going to come in there with her A game on. She's going to study up. She's going to be prepped. She's going to be this. She's going to be that. So, you know, she knows how to get up there and dodge bullets, right? So there's that. Anyways, let me know what you think down in the comment section below. I am very curious to get your opinion on this. And hopefully this will go up before she gets to testimony, because you know we're going to be talking about that, right? We are going to be live streaming this trial over on the podcast channel. I'll do quick updates over here on this channel with it, you know, to talk about it, whatnot, all the fun things. So stay tuned. So while you are in that comment section, if you could please drop off some little blue sofas for myself, Roscoe and Spirit, you know, got our little pillow version of them at least, Bo and Luke, and you, the Sofa Squad, who make the channel possible. I do appreciate you for that. And until we all gather down in that comment section to hang out and do what we do down there, I'll see y'all soon.
I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. And then, like I said in the beginning of the video, if you want to follow me and Roscoe on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.
Hey, welcome to the Sofa Squad. Sipping from the cup that, hey, come loud. life with the Sofa Squad. Can't roll my damn eyes hard enough.